Assalamualaikum warahmatullahi wabarakatuh. My name is Aina Rahman and we are from Group 6. Today, we will present about the topic Evaluation of Sources of Malaysian Law. In this topic, we will be discussing on the three major sources of law in Malaysia. Next is the reception of English law in Malaysia. The British colony was established in 1786 in Penang. Then it spread to Singapore and also Malacca. This was known as the Straits Settlement. Portuguese occupied Malacca from 1511 to 1641. Sultan of Malacca fled first to Pahang, and then Johor, and then Riau Archipelago. The attack on both Johor and Aceh in Sumatra was unsuccessful. Therefore, attacks were made on Malacca. Aceh and Johor also fought each other. The main issue in these struggles was control of trade through the Strait of Malacca. Next, it is the Strait Settlement Act. So, the first territory to be acquired by British was in Penang, and it was in 1786. However, it is unclear thus. There are many theories on this matter. In 1608, the principle was established that English settlers took English law with them when they entered the new territory. This is known as the Doctrine of Reception. In 1826, the three British East India Company territories, which is Singapore, Penang and also Malacca, were given a unified administration known as the Straits Settlement. Next, we move on to the Second Charter of Justice. This charter introduced English law into the Straits Settlements. However, there are controversies. Sir Edward Rice, which is the first recorder of Penang, was of the view that the Charter of Justice still allowed the locals to freely exercise their religions, customs, usages and also habits. Next is the Third Charter of Justice. This was introduced into the Straits Settlement in 1855. The purpose of this is to remedy the deficiencies in the system. This charter repealed the former charter in order to reorganize the Court of Judicature. Next is the Malay States. The Civil Law Enactment 1937 gave statutory authority for the introduction of English common law and equity to the Federated Malay States. In 19th century, Malay states consisted of Perak, Selangor, Pahang and also Negeri Sembilan. They have their own law called the Malay Customary, modified by the principles of Sharia law. This was before the intervention of British. When British came, the process of Islamized Malay Adat law was arrested. In 1895, the four Malay states formed as the Federated Malay States. The other five states, which are Johor, Kelantan, Terengganu, Kedah and also Perlis, did not join, and they are called as the Under-Federated Malay States. These states were independent and also ruled by their sovereigns. Lastly is the Sabah and Sarawak, or can be called as Borneo states. They were British protectorates in 1888. However, the formal reception English law in Sarawak only took place in 1928. This took place with the Law of Sarawak Ordinance 1928. The ordinance stated that the law of England, subject to modifications by the orders of Rajah so far, was implicable having regards to native customs and local conditions. These provisions have been reproduced in the Civil Law Act 1956. Lastly, in 1978, Islamic law and Malay customary law were administered by the Islamic Council and also Sharia Court. That's all for the Borneo states.
So, Assalamualaikum, my name is Batrisyia. So, I will continue to the common law and equity. The English legal system has four sources. Firstly, folk laws and customs. The second one, which is Roman law. The third one, Jutes, Anglo-Saxon and Danes. And the last one, which is Normans. So here we have the development of common law. The development of common law has three stages. The first stage, which is pre-1066 Anglo-Saxon period. Prior to the Norman conquest, the legal system of England was not unified. It was fragmented. There were different systems of law applying to different parts of England. For example, the northern and northeastern part of England applied Dane law due to the invention and settlement of the Vikings in those parts. The Midlands applied Mercian law, which was born out of the Saxon invention from Germany. South and west of England adopted Wessex law. So here we have an example diversity with regards to inheritance law. The firstly is primogeniture. The eldest son inherits his father's land. This law was applied in most part of England. Second one, which is gravel kind. All sons inherit equally. This was applied, for example, in Kent. The last example, which is Borough of English, the younger son inherits the land. This system was followed in Bristol and Nottingham. Okay, for the second stage, we have post 1066 after the Norman conquest. In 1066, William of Normandy defeated the Anglo-Saxon king at the Battle of Hastings and became King of England. He was a powerful king and could therefore easily transfer most of his power to the central government. So here, William introduced the concept of feudalism, where he owned all the land and let the land to the lords in return for their services. He also made the Wissenstrong and renamed it the Curia Regis. The Curia Regis was made up of the peers of the land who advised him. So for the last stage, we have Henry II onwards. Due to the hardship of going to Westminster for court cases, Henry II developed the system known as the itinerant justice. He faced hardship when going to the Westminster. The first hardship that he faced, which is the journey was long and delay in hearing cases as local witnesses could not be found. Due to the above hardship, people did not go to the royal courts. However, the local courts were also not popular because they were frequently corrupt, biased and unfair. To solve their problem, King Henry II introduced the system of itinerant justice. The system of itinerant justice means a system whereby the country was divided into circuits and the itinerant justice will go on their rounds to decide cases. The original justices who sat in these courts were untrained and therefore relied on the information of locals to find out the fact and the particular local law. This brought about the introduction of the jury system.
Equity is a body of rule which were enforceable in the Court of Chancery. Before the Judicature Act 1873-5 fused the system with the common law. Equity was developed as a separate system from common law, since it was developed to fill the gaps and to remedy the defects under the common law system. This is why equity is also known as gloss on the common law. Another purpose of the equity is to recover the defect of the common law. So the first defect of the common law is the inflexibility of the writ system. There is a specific writ for every civil wrong, and the aggrieved person will apply for the writ that was most appropriate for his claim. So if the wrong writ was obtained, the injured party will not be able to have his case heard. So the next defect is much bribery and corruption at common law. Money is everything, so person of wealth and power could put pressure on the courts to decide for their favour. And the third is the common law courts lack jurisdiction to hear certain cases. This contains instances where foreign merchants were involved in a dispute and the common law courts lack jurisdiction to hear the issue. The weakness of the common law system were exacerbated as a result. So this is not fair to the foreigner. The next defect is inadequacy of the common law remedies. In a simple word, some cases of compensation in the form of money, but there are also cases where the money is not enough to bear the good. And the last one, failure of the common law used to recognize the use or trust. In simple words, person A hand over the trust to person B hand it over to the person C. However, if there is a problem with the trust held by person C, only person A is responsible.
The reception of common law in Malaysia. Common law was introduced to the strict settlements through the Royal Charters of Justice, and then the application of the common law was extended to the Malay states through the administrative arrangements. On specific matters, it was based on British Indian models. Unfortunately, the Malay Adat was replaced by the common law as the basic rules of the land. In 1963, Malaysia was formed and the application of English law was authorized by 3 separate statutes. So the first one is the CLO 1956 in Peninsular Malaysia. The second one, application of Laws Ordinance 1951 in Sabah. And the third one, application of Laws Ordinance 1949 in Sarawak. After Malaysia was formed, the formerly known as CLO 1956 was extended to East Malaysia by the Civil Law Ordinance Extension Order 1971. Civil Law Act 1956, Act 67, revised 1972 or known as CLA 1956, incorporates all the 3 earlier statutes, and it is also the statutory authority application of English law in Malaysia. The application of English law can be seen in 3 different sections. The first one in section 3, the second one in section 5, and the last one in section 6. The call for a Malaysian common law. The call for a Malaysian common law is not something new. The repeal of S3 has been advocated by numerous academicians and judges. S3 1 states that, save so far as other provision has been made or may hereafter be made by any written law enforced in Malaysia, the court shall, first one, in West Malaysia or any part thereof, apply the common law of England and the rules of equality as administered in England on the 7th day of April 1956. The second one, in Sabah, apply the common law of England and the rules of equity together with statutes of general application as administered or enforced in England on the 1st day of December 1951. And the last one, in Sarawak, apply the common law of England and the rules of equity together with statutes of general application and administered or enforced in England on the 12th day of December 1949, subject however to subsection 3, subject 2, provided always that the said common law, rules of equity and statutes of general application shall be applied so far only as the circumstances of the states of Malaysia and their respective inhabitants permit and subject to such qualifications as local circumstances render necessary. When does common law and rules of equity in Sabah and Sarawak and English statutes apply under S3 1 CLA 1956? It will apply subject to the following qualifications. So the first one, absence of local legislation, cut off dates and local circumstances. That's all from me and us. Thank you.